A will is a person's final wish, a legal document that speaks after death. But when a will is very old, proving its authenticity becomes a challenge. Witnesses may be gone, and the writer is no longer alive. Indian law must balance two things: allowing genuine old documents and preventing fraud. The Indian Evidence Act of 1872 provides the rules for this. When it comes to wills, the stakes are high. Families and fortunes can be at risk. The law creates presumptions to help courts trust old documents. The core issue is authenticity. How can a judge in 2025 trust a will from 1950? The law cannot demand the impossible, like living witnesses for a 70-year-old will. So it creates a special category for old documents, presuming them genuine if certain conditions are met. Imagine a family dispute over ancestral property. A 70-year-old will is produced and others claim it's a forgery. Without clear rules, courts would be left guessing. The Evidence Act steps in. If a document is over 30 years old and found in proper custody, the court can presume its signatures and handwriting are genuine. This presumption is the starting point for proving the truth behind an old will. It's a practical solution to a very human problem. The law's wisdom lies in making justice possible, even when time has erased direct evidence. This framework prevents chaos and ensures fairness in inheritance disputes. The presumption isn't absolute, but it gives courts a logical path forward. In essence, the law helps the past speak reliably to the present. Old wills, if preserved and found in the right place, are given the benefit of doubt. This is how the legal system balances trust and caution with old documents. The Indian Evidence Act's Section 90 lets courts presume documents over 30 years old are genuine. This helps when witnesses are long gone. But in Uttar Pradesh, a new rule, Section 90A, was added for registered documents. Section 90A allows courts to presume a registered document is genuine, but only if the person who executed it is dead. This created confusion. Did Section 90A override Section 90 for registered documents? Section 90 applies to any old document, registered or not. Section 90A focuses on registration, regardless of age, but with stricter conditions. The legal puzzle? If you have a registered will over 30 years old, which rule applies? If Section 90A is the only rule, proving a will gets harder. Lawyers and judges needed clarity. Could both sections coexist, or did one replace the other? This wasn't just theory. It affected real inheritance cases. The answer would shape how families proved their rights for generations. The stage was set for a crucial judicial interpretation. The law's future depended on resolving this conflict. The confusion reached the Allahabad High Court in the landmark Ramjas versus Surendra Nath case. The court faced a registered will over 30 years old. Should Section 90 or 90A apply? After careful analysis, the court ruled. Section 90 and 90A are independent. Section 90 is a general rule for all old documents. Section 90A is a special rule for registered ones. If a registered will is over 30 years old, you can use Section 90's presumption. If it's less than 30 years old, Section 90A may help if its conditions are met. This decision brought clarity and fairness, letting people choose the best legal path. The Ramjas case became the guiding precedent for proving old registered wills in Uttar Pradesh. The court's logic ensured justice wasn't lost in technicalities. Section 90A(2) added a twist. Its presumption doesn't apply to certified copies of registered documents. Certified copies are official duplicates from government records, often used when originals are lost. This rule made it harder to prove a will with just a certified copy. But what if the original is gone forever? The courts clarified. Section 90A's restriction on certified copies doesn't affect Section 90. If you have a certified copy of a registered will over 30 years old, you can still use Section 90's presumption. This interpretation was crucial for people relying on certified copies. The law remained practical, ensuring old, genuine wills could still be proved, even if only a certified copy survived. The courts protected access to justice, not just technical compliance. The system adapted to real-life challenges. The rules of evidence are the backbone of justice. Section 90 and 90A are tools to help courts find the truth when direct proof is lost to time. The Ramjas decision reinforced that both sections serve justice, not bureaucracy. Section 90 honors the reliability of age. Section 90A recognizes the formality of registration. Both presumptions are rebuttable. Opponents can still challenge a document's authenticity. The law shifts the burden, making the process fair and efficient. For ordinary people, the message is clear. An old registered will carries legal weight. The law provides a way to prove its contents even decades later. The system ensures that truth and justice can prevail, no matter how old the evidence. This is the living spirit of the Evidence Act, balancing trust, caution, and fairness.